All right, good morning. Ms. Francisco, can you hear me okay?
Yes.
All right, and Mr. Francisco?
Yes.
All right, Ms. Vandrew?
Yes, thank you.
All right, good morning, everyone. My name is Caryn VanderHeuvel. I'm an attorney referee. We're here today on case B 2014-3089-DM, and I am recording today's hearing. Ms. Francisco, I'll start with you. Name and address for the record, please.
Gabrielle Francisco, 6269 Twin Lakes Court, Kimball, Michigan, 48074.
Thank you. And Mr. Francisco, name and address for the record, please.
Scott Francisco, 4308 Old Forge Drive, Fort Gratiot, Michigan, 48059.
Thank you. And Ms. Vandrew, your appearance.
Dina Vandrew on behalf of Mr. Francisco.
Thank you. Two minor children on the case, Serena, date of birth April 7th, 2009, and Corbin, May 20th, 2011. Judgment of divorce entered in 2015, giving the parties joint legal and joint physical custody, primary residence with mother, specific parenting time schedule with father, and he is payer of support at $5.59 per month. We're here today because on April 22nd, Mr. Francisco filed a motion to review the current support order. Ms. Vandrew, what's the basis for the motion today?
The basis of the motion is all related to childcare. So the party's eldest daughter is now 12 years old, and my client had contacted friend of court staff to let them know, because that would obviously reduce the childcare payments. And he was told that it was just going to shift all to Corbin's benefit. So we want to have the childcare expenses reviewed. Also, the parties have modified the schedule by agreement during this COVID and periods of virtual schooling to reduce their childcare expenses. And my client tried to communicate with his ex-wife directly about this topic to find out what the actual childcare expenses are, and really hasn't gotten any information back. So it's our opinion that childcare has not been paid for several months. And at this point in time, we're asking that it be reviewed and verified so that the child support amount is set accurately.
All right, thank you. Ms. Francisco, what is the current childcare arrangement?
With the new schedule that we had through the start of the school year in September, all the way until March, I used the current sitter that I had sent over in the emails to you. Because the school was in and out on Fridays, it was a Friday every other week, and then a Saturday every other week as well. 12 hours one week, 6 hours the next, 12 hours the following, and 6 hours the next. That was the schedule that me and her had worked through. Until March of this year, she was with me, and then 2 months ago, she took another position. So she's no longer with me. And now we are at a different.
So was there ever a time when you stopped paying childcare?
We lost. She kept talking, and I couldn't hear anything she said. I think we lost volume.
All right. Ms. Francisco, can you still hear me?
Yes, I can hear you now.
Okay. So what I got there was through March, you were paying. Starting in March, your sitter took a different position. What have you been doing for childcare since March?
Since March, I have not had anybody. I've not been able to secure anybody, but that was based on the fact that I wasn't sure whether the kids were going to be back or not in school. So at this point, I no longer am in need of a childcare provider at all.
Okay. And that was, what was the effective date on that?
I'm going to say March 1st of 2021.
Okay. And as far as summer childcare, any expectation that you'll be paying for childcare this summer?
No.
So Ms. Vandrew, based on that, what is your client requesting?
Just that the childcare portion of the child support order be eliminated as of March 1st.
Of 2021?
Yes, please.
And Ms. Francisco, under the current order, Mr. Francisco is ordered to pay $5.59 per month. Of that, $1.59 is childcare. So what Ms. Vandrew is asking is that effective March 1st of this year, that support obligation be reduced to $400 per month for both children, as it would not include any childcare. Do you have any objection to that, ma'am?
Is he asking for termination on all of his childcare as well? Because in the letter it said that the childcare expenses that he would see would want either a reduction or termination through everything.
Okay.
Is he no longer needing childcare?
Ms. Vander?
That is my understanding. Am I right about that? Scott, you're not paying childcare anymore either, correct?
Not at this point in time. For the summer, I guess at some point we probably will. And if I need be, I guess I just take care of that on my own accord, or would I turn that in? I guess that would be my question.
We could probably jump off that bridge if the costs are incurred and figure out what best to do at that point in time.
They have me
Okay.
as the payer of childcare. And so if I'm no longer requiring childcare and he's no longer requiring childcare, I would like it as if he could just take care of his own childcare provider, because he was sending over his sitter so that I could make sure to pay her. So if we could switch that up somehow so it's written that he can provide the pay of his own childcare provider.
So the current order that we have from 2019, when that calculation was done by referee Messing, we had Ms. Francisco as the payer of childcare, and we did not have Mr. Francisco as payer. And according to Mr. Messing's notes, he understood that both parties were paying some childcare, but he ran the calculation as though mother would be paying the entire expense and then father would be reimbursing him for a portion. So when I'm talking about stopping the childcare obligation at this time, that means mom would not be reimbursed for any of those, but dad would also not receive a credit for anything he's paying. And in the future, if he is paying childcare and wants to receive a credit on his child support for that, he would need to file a motion, and we would have another hearing like this one to do that calculation. But at this point, if I recommend that the child care of the $159 a month stop, that means that there is no child care charging through friend of court for either party. Ma'am, does that answer your question?
Yes.
Okay. Ms. Vander, any questions about that or any objections?
No questions or objections about that.
Okay. So what I will do based on the motion filed by Mr. Francisco is recommend that the child care obligation of $159 a month stop effective March 1st, 2021, as mother is reporting that she has not been incurring child care costs since that time. And then support would continue to charge with father as payer at $400 a month for 2 children. In the future, if either party has another change of circumstance or any child care costs, then you would need to file a motion and we'd have another hearing to review support. Ms. Francisco, anything else today?
No, I did have, when I sent in a different total, and I've tried to get this kind of corrected throughout, of an overnight total, but I have not had anybody, based on going to court, been able to review that overnight total. So because I sent that all in and we are going through a new total of numbers, is that able to be looked at today?
Well, is it something that has changed, ma'am, or is it something you believe was an error in the previous calculation?
Correct. An error in the previous calculation.
Okay, if you thought that there was an error in the previous calculation, then you needed to object to that calculation, raise it at the time, and have the judge speak to it. But now I have a calculation that's 2 years old. And the motion that was filed by Mr. Francisco was addressing the issue of childcare only. It did not include a request for review of overnight.
Yes.
If that's something that you want us to take a look at, then you would need to file a motion and I would.
Correct.
I
Yes.
could do that. And then I would look at both parties' income and any other changes that have taken place.
Okay.
But at this point, the only issue that's been raised is that childcare.
Correct.
Okay.
Yes.
Ms. Vander, anything else?
The only other thing I'll say, just because both parties are in attendance, is my client, we haven't filed a motion regarding parenting time. The kids are expressing some dissatisfaction with all the back and forth. And my client was wondering if Ms. Francisco would be interested in attending mediation on the parenting time issue.
Well, and that's certainly not something, I'm going to push today. That's not what we're here about. But Ms. Vander, as you're aware, and I'm sure you can talk to your client about it, if you request mediation through our office, then Ms. Cogley will send a letter to Ms. Francisco asking whether or not she is interested in participating. And if she answers in the affirmative, then Ms. Cogley will be more than happy to schedule a mediation session. But mediation, as you know, is voluntary in nature. You're not required to participate. We certainly encourage parents to participate in mediation. I think it's a very beneficial process, but that's not something that I'm ever going to force, obviously, a party to take part in. And if mediation is not successful or does not take place, then certainly a parenting time motion can always be filed and we'd have a referee hearing.
Sure. Okay. Thank you.
All right. I want to wish both of you and the children the best of luck. My hearing
Can
is
I raise just one more point? I'm sorry. It'll be brief. Just a question on, there's talk that she is moving and it's going to be out of the district where Corbin attends right now, which is Indian Woods. So there's talk about that he was potentially going to move to a different school. I guess what is is there an unwritten rule or written rule on that as far as with her moving, me being notified, or him moving schools? Does that make sense?
Yes. Yep. There's that 100-mile limit. Obviously, when you share joint legal custody, neither party can move the more than 100 miles. That's a separate issue than the school attendance issue. Oftentimes, what we look at is district. Are they changing districts or it's simply building? I will note that the judgment did award Ms. Francisco primary residence for purposes of school attendance. And the way we interpret that is if mother changes neighborhoods or moves homes within the same district, then the child should attend the school that is closest to mother's home. I mean, that's the primary residence designation. But certainly with joint legal custody, that's something I would expect the two of you to discuss like adults, reach an agreement on, have communication about. And if that's something that you are not in agreement with, then you can certainly talk to Ms. Van Drew about filing a motion for joint legal custody relief if you're asking that the school of attendance not be changed. But the reality is that people do move, and the courts will look at if there is a negative impact on the child. And so there's all sorts of factors that are weighed on that. But again, we always ask parents to start with an adult conversation about what's best for the child and the reality of the situation. So I want to wish both of you the best of luck on that, and look for my recommendation. Yeah. Go ahead, sir.
With that, so I guess with that, that makes sense, and it's not going to be more than 100 miles. I don't have the issue with the moving or whatever. It was just with moving schools because he's 5th grade is next year. It's his last year there. He's been there since kindergarten. So with my daughter, she's at Fort Gratiot, yet Gabe's address would be Central Middle School. So we've used my address in order for her to attend Fort Gratiot Middle School. So it's just now okay, she's moving, she wants to move to this different school. But I have asked before to move Corbin into kind of the same at Thomas Edison, which would be the same thing. So I just felt like, okay, we were using my address for her to go to Fort Gratiot Middle School, and, Corbin couldn't attend within that same area to Thomas Edison. But now because she's moving, she wants to take him over to Keewatin, and I just, you know what I mean? That's kind of where I'm at.
And again, I'm not the person today to solve this issue. This is, again, something that the two of you, as the parents of Corbin, need to sit down, make your list of pros and cons. Ma'am, if this is something you are thinking about, and I don't have any evidence in front of me that you even are, but that's something that you need to discuss with the other parent. Here's what I'm thinking, and here's why, and let's talk about our options. That's what co-parents do. And I know it's not always easy, but that is what is best for your children, that you communicate with adults. So, please do your best on that. And if you two can't resolve it between yourselves, then the courts will step in and resolve it for you. That's not the way we want to go. I don't think it's ever in a child's best interest to have a referee or a judge make a decision for a child. It's always best if their parents can do that. But if parents are unable to do that, so certainly there's ways to resolve it through the courts. Okay? All right.
Yeah,
Look for
communication's a big problem in this case. I hope that they can mediate and maybe try to work through some of this stuff.
Yeah, and when people say, boy, we can't communicate or it's really tough, you both seem like very intelligent adults working in the real world. You know how to work with coworkers. You know how to get along with people that maybe you're not best friends with. I always tell couples that you now have a professional relationship. You are coworkers, and your job is raising these children. So you need to treat the other parent like you would a coworker, respectfully, and use your best manners and don't make it personal and don't, go back in history and bring up stuff from 10 years ago. I mean, this is a co-working relationship and you got one job and that's, again, not always easy, but you need to approach it in a way that you're always doing what's best for your children. So, and if you both do that, then you can't fail. But so Ms. Cogley is very good at her job. Please consider mediation on this issue and any other that you're struggling with. And I wish you luck. So I'm going to put the child care recommendation into writing, mail it out to both parties and Ms. Van Drew. You'll each have 21 days to review it and object if you choose. If there's an objection, we'll schedule a hearing with Judge Brown. If there is no objection, he'll go ahead and sign it. My hearing's adjourned and have a great day.
Thank you.
Thank you.
Thank you.